Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I am Attorney Elsa W. Smith, owner of the law offices of Elsa W. Smith, your Maryland estate planning attorneys, where our mission is to empower women through estate planning. A bit of housekeeping before we move forward. Please give StreamYard permission to view your comments, and you can go to StreamYard.com/Facebook. Again, StreamYard.com/Facebook. Today's topic is how choosing the wrong fiduciary can ruin your estate plan. Again, how choosing the wrong fiduciary can ruin your estate plan. Now, today's episode is broken down into two parts. First, I'm going to explain what a fiduciary is and explain where you would need a fiduciary in your estate plan and who can serve as a fiduciary. Then I'll discuss how choosing the wrong fiduciary can really ruin your estate plan. So let's get started. First, what is a fiduciary? A fiduciary is a person or corporation who holds a legal or ethical relationship of trust with another person or group of people. In other words, a fiduciary is someone who's acting for and on behalf of another in a specific way, in a particular manner, in circumstances that give rise to a relationship of trust and confidence. Now, a fiduciary is expected to be extremely loyal to the person to whom he or she owes that duty and must not profit from the position as a fiduciary. A fiduciary can receive a fee for services. However, he or she shouldn't profit at the expense of the other party. In the customer or client context, a fiduciary is obligated to follow both a duty of care and a duty of loyalty, to their clients. A duty of care requires that a fiduciary place their client's interest ahead of their own. Under a duty of loyalty, the fiduciary must also attempt to eliminate all potential conflicts of interest. And when that is impossible, they must fully disclose those conflicts of interest to their clients. As attorneys, we have a professional code of conduct that we must abide by. And we are required to disclose any potential conflicts of interest to our clients. Now, what are some fiduciary roles that you would have in a typical estate plan? Now, every estate plan is different. The average plan, however, is going to have more than one fiduciary role. The common examples of fiduciary roles are that of a personal representative. Some states refer to that as an executor. In Maryland, we use the term personal representative. When you create your will, you will be required to appoint a personal representative who is responsible for overseeing the administration of your estate during the probate process. Personal representatives are typically appointed in a will and are given control of assets during the probate process until those assets are ultimately, distributed to named beneficiaries. Personal representatives are responsible for collecting, marshaling all the assets of the deceased, paying financial debts, paying expenses, and filing any estate tax returns. You also have the role of a trustee. If you incorporate a trust agreement in your estate plan, you will need to appoint a trustee. Your trustee is going to manage and invest trust assets as well as administer the trust agreement according to the terms that you created. You also have an agent in a power of attorney. When you create a power of attorney, you have to appoint an agent, also known as an attorney in fact, who will have the legal authority to act on your behalf in legal matters. You also have an agent in an advance directive. If you create an advance directive, you will need to appoint an agent to make healthcare decisions for you if you are unable to make them yourself because of your incapacity. We also have guardians for minor children. Now, guardians are actually fiduciaries to the wards. In this case, fiduciaries to the minor children. They owe a duty of care and to act in the best interest of those minor children. And you would name a guardian in your will. You also have successors to all of the roles that I mentioned, or backups to all of the roles that I mentioned. Now, who can serve as a fiduciary? Fiduciaries, as I said before, they can be people or corporations, but fiduciaries include personal representatives. They can be real estate agents, they can be physicians, attorneys, and financial advisors, all of whom are obligated to act in the best interest of their clients. Now, with respect to that last category of financial advisors, I know that there are many financial advisors out there with many credentials attached to their names. Some do, some don't. It's important for you to specifically ask your financial planner or advisor if they are a fiduciary, meaning are they obligated to act and invest in your best interest. We as attorneys have a fiduciary duty to act in the best interest of our clients. Now, how can choosing the wrong fiduciary ruin your estate plan? Appointing the wrong person to a fiduciary role is among the common estate planning mistakes that we see. Now, to prevent you from making a mistake, I want you to ask yourself the following questions when choosing a fiduciary. The first is, does he or she have the necessary skills and experience? Now, not all fiduciary roles require specific skills, but some do. A trustee, for example, should ideally have a legal or a financial background. Trustees control the assets held within trusts, which may have been set up during a person's life or at death under the terms of a will. A trustee's role can continue in perpetuity or until the trust is terminated. And trustees generally bear their responsibility for investments, accountings, and tax filings. The next question you want to ask yourself is it someone that you trust implicitly? You know, a fiduciary typically makes extremely important decisions as well as handle valuable assets. You have to be able to trust the fiduciary unquestionably. Next question. Will this person be capable of fulfilling the role? Does the person live close enough to you? Will his or her job allow sufficient time to perform the duties required? Will the person be able to set aside emotions and think clearly when necessary? Next question. Is this person willing to accept the appointment? Do they want it? Never assume that someone is willing to be your personal representative, your, trustee or successor trustee or an agent. Always ask them directly before appointing them. And then 5, does appointing that person create any conflicts? There are many potential conflicts in an estate plan. For example, if your trustee has an existing personal relationship with one beneficiary and not with others, it can create a conflict. Okay, now that you've heard those 5 questions that you should ask yourself when considering a fiduciary, I want you to think about the people in your life. You don't have to limit this to family members. Think about each person's strengths and weaknesses. We all have them. For example, say your cousin is a very stylish and really nice person, or she's a really nice person, but she can't manage money. Or worse, she has a long track record of bouncing checks and bad credit. Then you can see how she would not be a good fit to serve as your financial power of attorney. On the other hand, let's say that your sister is the person that people typically turn to when they need someone they can count on. She is methodical and very detailed. She'd be a good fit for a power of attorney agent while you're alive, and personal representative or a trustee if you have a trust incorporated into your estate plan. And say your brother is great with kids and your kids love him. He has a stable job and his values are pretty aligned with yours. He would be a good choice to serve as your kid's guardian if, say, you and your spouse were to pass away. I want you to think about why a person is the best choice for the role that you've chosen for them. Make an honest assessment of people's skills and character when trying to put the right people into the right roles. It's also important to ensure that people are aware of, willing, and able to take on the roles that you are assigning them. Let's look at the advanced directives, for example. Let's consider the role of the healthcare agent. I had a client who was really torn about who to name as her healthcare agent. She thought she would go with the default choice of, that being her husband. However, during the course of me representing her, she shared that her husband tends to freeze in situations where, serious medical choices or serious decisions have to be made. She loved him dearly, but she wasn't confident that he could carry out her wishes regarding the care that she wanted or didn't want if she were in an end-of-life situation. I explained that appointing the wrong person could delay treatment that she needs, and it could add unnecessary stress to the family due to his inaction. Another way of viewing it is if she were on life support and she had written in her advance directive that she wanted to be taken off life support for after a period of time, or that she didn't even want life support. And let's say the husband insisted on keeping her on life support despite what she had written in her advance directive. He would not be carrying out her wishes, which would cause a tremendous amount of conflict between he and the family, as well as put, the doctors in a very awkward situation. Now, I also want to share about a consultation. Eventually, this person became my client, but she struggled to pick one of her kids to serve as a personal representative. She shared that she was afraid to pick one over the other. She had three kids. And she was afraid to pick one over the other because she didn't want to hurt anyone's feelings. And she kept going on and on about, well, this person's going to be felt left out if, I need to put them somewhere, is what, in essence, what she said. And so she was making estate planning decisions from a guilt space. And at that point, I had to say, stop. She was afraid that it would lead to jealousy or hurt feelings. And I had to remind her that this was her plan, not theirs. Working with me gave her the safe space that she needed to express herself. And I provided her with the guidance that she needed to make the best choice for each role. I even told her, I said, look, if you want to name me as the bad guy, as the villain, you can say, hey, my attorney said that I needed to do X. But the point is that I wanted her to be confident in the decisions that she made. And I also wanted them to be informed decisions that would help her in her estate plan. Now, listen, if you don't have an estate plan, I created a guide to help you get started. It's called the Jumpstart Estate Planning Guide. I'd like you to get the guide. It's free. More importantly, use it, share it, and I'll post the link below this video. We've talked about a lot today, how choosing the wrong fiduciary can ruin your estate plan. I also gave you some questions to consider when you're thinking about including someone in one of these important roles. Choosing a fiduciary is extremely important. It's also important for you to work with someone who can guide you through the process if you're struggling a bit choosing the right person for the right roles. This is where an estate planning attorney would be beneficial. This is what I do, and I help my clients do this every day. So if you're in need of assistance, I want you to feel free to contact us at the law offices of Elsa W. Smith. You see our contact information there scrolling on the bottom of the screen, 410-995-7719 if you're in Maryland or the District of Columbia. I want to thank you for tuning into this episode of Women Winning Wednesdays. If you need assistance, want to schedule a strategy session, give us a call. You can always also reach us online on our website at elsawsmithlaw.com. We are here to help. Join us next week for another episode of Women Winning Wednesdays. I'm Attorney Elsa W. Smith, your Maryland estate planning attorney, empowering women through estate planning. Thank you for watching. Take care.